You may call the case, please.
Good morning, Your Honors. The matter before the court this morning is the case entitled Violet Nichols versus Robert Lafayette, case number 24 AP 288. Appellant Robert Lafayette is self-represented. Appellee Violet Nichols is not appearing.
All right, appellant, please introduce yourself and you may proceed with your argument.
So I'm Robert Lafayette, the appellee. May it please the court. This case presents a clear legal issue, question, and that question is whether or not communication speech directed at a public official over education disputes can serve the basis for this stalking order that we're here today on. The stalking statute itself exempts constitutionally protected speech. In this case, that conduct and activity includes ongoing Department of Education Office for Civil Rights Title IX investigation, as well as Title IX retaliation investigation. There were also housing and residency disputes, all of which were constitutionally protected. And further, Nichols is a public official and must tolerate criticisms that are under higher scrutiny than a regular person. A public official must tolerate criticisms under established case law, such as Popa versus the United States, which holds that repeated, even harsh criticisms of public officials is protected speech. And I would argue that and I think that there's case law that supports this, that most of the hearing at the trial level talked about incidents that took place at a school board meeting that were inconvenient and offensive. But at no point is there a direct, overt, true threat as established, like Watts versus the United States. There was heated rhetoric and so forth, but there wasn't a who, a what, a when. And on cross-examination during the trial, the alleged victim, the appellant, broke down during that testimony and said, well, please identify a threat, and when pressed, was unable to identify one. And then finally, when pressed, admitted that there wasn't a 918 multiple voicemails. There was, in fact, one voicemail, and on that cross-examination, she admits that the other one seems to have been a pocket dial or unintentionally left, which also fails the statute's requirement for a course of conduct. If you were to consider the activity of 918 to be outside the boundaries, that still is a single event and wouldn't establish a course of conduct. But that is where we're at today. And I just would argue again that public forum protections are at the highest. They receive the highest level of First Amendment protections. And there's some case law that establishes that. And then finally, the statute's overbroad. They used a paintbrush when they needed a pencil. It includes people that I do not know that just populated to me based off a background check that I used to obtain because I'm suing this appellant in a civil matter. So as I stated in the trial court, I used a service to run a background check to obtain the person's mailing address, which also populates their phone number and so forth in there. And so they included everybody in that list, which I have no idea who they are. So I'm in constant jeopardy of my liberty with no specificity as to who they are and so forth. And that's essentially the position of the undersigned. And I don't need to take up more of your time today.
All right, thank you very much. Is counsel for the appellee participating?
They're not.
They are not. Very well then, the bailiff may call the conclusion of the case.